When those communications are not secure, it puts their lives in jeopardy. This classified information is entrusted to very few, but there's such a duty and an obligation to protect that, to fall on your sword to protect that. And yet there doesn't seem to be any consequence. You know, I was talking to Trey Gowdy, and he made a really good point with us yesterday. Mr. Gowdy said, you know, in your statement, Mr. Director, you mentioned that there was no precedent for this. But we believe that you have set a precedent, and it's a dangerous one. The precedent is if you sloppily deal with classified information, if you're cavalier about it, and it wasn't just an innocent mistake, this went on for years, that there's going to be no consequence. We're a different nation in the United States of America. We are self-critical. Most nations would never do this. But we do it in the spirit of making ourselves better. There'll be all kinds of accusations about political this and political that. I have defended your integrity every step of the way. You are the definitive voice. I stand by that. But I am mystified, and I am confused, because you listen to your fact pattern and come to the conclusion that there is no consequence. I don't know how to explain that. We'll have constituents ask us, they'll get mad, they'll panic, you know, they're frustrated. They've seen this happen time and time again. I don't know how to explain it. And I hope that through this hearing, we can stick to the facts and understand this, because there does seem to be two standards. There does seem to be no consequence. And I want to understand that. And I want to be able to explain it to the person that's sitting at home. And that's why we're here. And so I yield back. Now I recognize the ranking member, Mr. Cummings.
Director Comey, thank you for being here today. I want to begin by commending you and the public servants at the FBI for the independent investigation you conducted. You had a thankless task. No matter what recommendation you made, you were sure to be criticized. There's no question that you were extremely thorough. In fact, some may even say you went too far in your investigation. But of course, that was your job. That is your job. Secretary Clinton has acknowledged that she made a mistake in using a personal email account. And you explained on Tuesday that she and her colleagues at the State Department were extremely careless with their emails. But after conducting this exhaustive review, you determined that no reasonable prosecutor would bring a case based on this evidence. And you and the career staff recommended against prosecution. Based on the previous cases you examined, if prosecutors had gone forward, they would have been holding the secretary to a different standard from everyone else. Amazingly, some Republicans who were praising you just days ago for your independence, for your integrity, and your honesty instantly turned against you because your recommendation conflicted with the predetermined outcome they wanted. In their eyes, you had one job, and one job only: to prosecute Hillary Clinton. But you refused to do so. So now you are being summoned here to answer for your alleged transgressions. And in a sense, Mr. Director, you're on trial. Contrary to the claims of your critics, there is absolutely no evidence that you made your recommendation for political reasons, no evidence that you were bribed or coerced or influenced, no evidence that you came to your conclusion based upon anything but the facts and the law. I firmly believe that your decision was not based on convenience, but on conviction. Today, House Republicans are doing what they always do, using taxpayers' money to continue investigating claims that have already been debunked just to keep them in the headlines one more day. When they hear a political siren, they rush towards it over and over again, even if the evidence is not there. Exhibit A. Majority Leader Kevin McCarthy, who admitted on national television that Republicans established the Benghazi Select Committee to bring down Secretary Clinton's poll numbers. I didn't say that. McCarthy said it. The fact was confirmed by a Republican staffer on that committee who reported that he was fired in part for not going along with the hyper-focus on Secretary Clinton. I give House Republicans credit. They certainly are not shy about what they are doing. They've turned political investigations into an art form. If our concerns here today are with the proper treatment of classified information, then we should start with a review of our previous hearing on General David Petraeus, who pled guilty last year to intentionally and knowingly compromising highly classified information. The problem is, Mr. Director, we never had that hearing. This committee ignored that breach of national security because it did not match the political goals of the House Republicans. If our concerns today were with finally addressing a broken classification system in which security levels are arbitrarily changed up and down, that would have been a legitimate goal. That would have been a valuable addition to reforming and improving our government. After all, we are the Government Reform Committee. We could have held hearings here on Zika. The Zika. Mr. Director. So in this moment, and this is a critical moment, I beg you to fill the gap. Because when the gap is not filled by you, it will be filled by others. Share with us, the American people, your process and your thinking. Explain how you examine the evidence, the law, and the precedent. Describe in clear terms how you and your team, career professionals, arrived at this decision. If you can do that today, if you can do that, that could go a long way towards people understanding your decision. Finally, I want to make it clear that I condemn these completely unwarranted political attacks against you. They have attacked you personally. They have attacked your integrity. They have impugned your professionalism. And they have even suggested that you were somehow bought and paid for because you made your recommendation based upon the law and the facts. I know you're used to working in the world of politics, but these attacks have been beyond the pale. So you do not deserve this. Your family does not deserve it, and the highly skilled and dedicated agents of the FBI do not deserve it. I honor your professionalism and your service to our country. And again, even if it takes till hell freezes over, I beg you to close the gap. Tell us what happened between what you found and your decision so that not only the members of this panel and this Congress will understand, but so that Americans will understand. And if you do that, then it will be all worth it today. With that, I yield back.
Mr. Chairman.
I think hold on one second. With your indulgence, to the ranking member, of which I have the greatest respect, you asked for a hearing on General Petraeus and how that was dealt with. You got it. We will have one in this Oversight Committee, and the record will reflect that in the Judiciary Committee, I repeatedly questioned Attorney General Holder. I repeatedly questioned the FBI Director about the disposition of that case, probably more than any member in the House or Senate. And if you want a hearing, we'll do that.
Mr. Chairman, you?
Yes.
Thank you.
Number two, you complained that we haven't done a hearing on Zika. The Oversight and Government Reform Committee, I believe, was the very first committee to actually do a hearing on Zika that was chaired by Mr. Micah. And I'm proud of the fact that we did a Zika hearing, and we did it first.
Mr. Chairman, Gill?
Sure.
Do we have another one? Because the problem is still there.
Absolutely.
Big time. Thank
Absolutely.
Mr. Chairman, I just unanimous consent request that we put the date of the hearing in the record at this time that I chaired. Thank you.
Absolutely. And the ranking member knows that we have held multiple hearings on the criminal justice and criminal justice reform. You asked for it, you're passionate about it, and we did do that as well. So to suggest we haven't addressed some of those issues, I think is inaccurate.
I don't think I did that, Mr. Chairman, but again, as late as yesterday with the problem in Minnesota with an African-American man being killed, I'd like to have some hearings still in the criminal justice system. Thank you.
Thank you, Chairman. Without objection, I'm going to work with you on that, as I have every step of the way.
Thank you, Mr. Chairman.
Without objection, the chair is authorized to declare recess at any time. We'll hold the record open for 5 legislative days for any members who would like to submit a written statement. We'll now recognize our distinguished witness for our first panel. Pleased to welcome the Honorable James Comey, the Director of the Federal Bureau of Investigations. We welcome Director Comey and thank you for being here. Pursuant to committee rules, all witnesses are to be sworn before they testify. If you'll please rise and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Let the record reflect that the witness answered in the affirmative. Mr. Comey, the floor is yours. You can take as long or as short as you'd like. If you have any written statement that you would like to submit afterwards, we're happy to do that as well. It will be made part of the record. The time is now yours. Director Comey, you're recognized.
Thank you, Mr. Chairman. Mr. Cummings, members of the committee, I am proud to be here today representing the people of the FBI who did this investigation as they do all their work in a competent, honest, and independent way. I believe this investigation was conducted consistent with the highest traditions of the FBI. Our folks did it in an apolitical and professional way, including our recommendation as to the appropriate resolution of this case. As I said in my statement on Tuesday, I expected there would be significant public debate about this recommendation, and I'm a big fan of transparency, so I welcome the conversation we're going to have here today. And I do think a whole lot of folks have questions about, so why did we reach the conclusion we did, and what was our thinking? And I hope very much to get an opportunity to address that and to explain it. And I hope at the end of the day, people can disagree, can agree, but they will at least understand that the decision was made and the recommendation was made the way you would want it to be, by people who didn't give a hoot about politics, but who cared about what are the facts, what is the law, and how have similar people, all people, been treated in the past. Maybe I could just say a few words at the beginning that would help frame how we think about this. There are 2 things that matter in a criminal investigation of a subject. What did the person do? And when they did that thing, what were they thinking? When you look at the 100 years plus of the Justice Department's investigation and prosecution of the mishandling of classified information, those 2 questions are obviously present. What did the person do? Did they mishandle classified information? And when they did they know they were doing something that was unlawful? That has been the characteristic of every charged criminal case involving the mishandling of classified information. I'm happy to go through the cases in particular. In our system of law, there's a thing called mens rea. It's important to know what you did, but when you did it, this Latin phrase mens rea means, what were you thinking? And we don't want to put people in jail unless we prove that they knew they were doing something they shouldn't do. That is the characteristic of all the prosecutions involving mishandling of classified information. There is a statute that was passed in 1917 that on its face makes it a crime, a felony, for someone to engage in gross negligence. So that would appear to say, well, maybe in that circumstance, you don't need to prove they knew they were doing something that was unlawful. Maybe it's enough to prove that they were just really, really careless, beyond a reasonable doubt. At the time Congress passed that statute in 1917, there was a lot of concern in the House and the Senate about whether that was going to violate the American tradition of requiring that before you're going to lock somebody up, you prove they knew they were doing something wrong. And so there was a lot of concern about it. The statute was passed. As best I can tell, the Department of Justice has used it once in the 99 years since, reflecting that same concern. I know from 30 years with the Department of Justice, they have grave concerns about whether it's appropriate to prosecute somebody for gross negligence, which is why they've done it once that I know of in a case involving espionage. And so when I look at the facts we gathered here, as I said, I see evidence of great carelessness, but I do not see evidence that is sufficient to establish that Secretary Clinton or those with whom she was corresponding both talked about classified information on email and knew when they did it, they were doing something that was against the law. So given that assessment of the facts, my understanding of the law, my conclusion was and remains, no reasonable prosecutor would bring this case. No reasonable prosecutor would bring the second case in 100 years focused on gross negligence. And so I know that's been a source of some confusion for folks. That's just the way it is. I know the Department of Justice. I know no reasonable prosecutor would bring this case. I know a lot of my former friends are out there saying they would. I wonder where they were the last 40 years, because I'd like to see the cases they brought on gross negligence. Nobody would, nobody did. So my judgment was the appropriate resolution of this case was not with a criminal prosecution. As I said, folks can disagree about that, but I hope they know that view, not just my view, but of my team, was honestly held, fairly investigated, and communicated with unusual transparency because we know folks care about it. So I look forward to this conversation. I look forward to answering as many questions as I possibly can. I'll stay as long as you need me to stay because I believe transparency matters tremendously, and I thank you for the opportunity.
Thank you, Director. I'm going to recognize myself here. Physically, where were Hillary Clinton's servers?
The operational server was in the basement of her home in New York. The reason I'm answering it that way is sometimes after they were decommissioned, they were moved to other facilities, storage facilities, but the live device was always in the basement.
Was that an authorized or unauthorized location?
It was an unauthorized location for the transmitting of classified information.
Is it reasonable or unreasonable to expect Hillary Clinton would receive and send classified information?
As Secretary of State, reasonable that the Secretary of State would encounter classified information in the course of the Secretary's work.
Via email?
Sure, depending upon the nature of the system. To communicate classified information would have to be a classified rated email system.
But you did find more than 100 emails that were classified that had gone through that server, correct?
Right, through an unclassified server, correct.
Yes. So Hillary Clinton did come to possess documents and materials containing classified information via email on these unsecured servers, correct?
That is correct.
Did Hillary Clinton lie?
To the FBI, we have no basis to conclude she lied to the FBI.
Did she lie to the public?
That's a question I'm not qualified to answer. I can speak about what she said to the FBI.
Did Hillary Clinton lie under oath?
Not to the FBI, not in a case we're working.
Did you review the documents where Congressman Jim Jordan asked her specifically, and she said, quote, "There was nothing marked classified on my emails, either sent or received," end quote?
I don't remember reviewing that particular testimony. I'm aware of that being said, though.
Did the FBI investigate her statements under oath on this topic?
Not to my knowledge. I don't think there's been a referral from Congress.
Do you need a referral from Congress to investigate her statements under oath?
Sure do.
You'll have one. You'll have one in the next few hours. Did Hillary Clinton break the law?
In connection with her use of the email server, my judgment is that she did not.
Did you just not able to prosecute it, or did Hillary Clinton break the law?
Well, don't want to give an overly lawyerly answer. The question I always look at is there evidence that would establish beyond a reasonable doubt that somebody engaged in conduct that violated a criminal statute? And my judgment here is there is not.
The FBI does background checks. If Hillary Clinton applied for the job at the FBI, would the FBI give Hillary Clinton a security clearance?
I don't want to answer a hypothetical. The FBI has a robust process in which we adjudicate the suitability of people for employment in the Bureau.
Given the fact pattern you laid out less than 48 hours ago, would a person who had dealt with classified information like that, would that person be granted a security clearance at the FBI?
It would be a very important consideration in a suitability determination.
You're kind of making my point, Director. The point being, because I injected the word Hillary Clinton, you gave me a different answer. But if I came up to you and said that this person was extremely careless with classified information, the exposure to hostile actors, had used, despite warnings, created unnecessary burdens and exposure. If they said that they had one device and you found out that they had multiple devices, if there had been email chains with somebody like Jake Sullivan asking for classification changes, you're telling me that the FBI would grant a security clearance to that person?
I hope I'm giving a consistent answer. I'm not saying what the answer would be. I'm saying that would be an important consideration in a suitability determination for anybody.
And it's just, personally, I just think that sounds like a bit of a political answer, because I can't imagine that the FBI would grant a security clearance to somebody with that fact pattern. Do you agree or disagree with that?
I just say what I said before. Again, it's very hard to answer in the hypothetical. I'll repeat it. It would be a very important consideration in a suitability determination.
Did Hillary Clinton do anything wrong?
And what do you mean by wrong?
I think it's self-evident.
Well, I'm a lawyer, I'm an investigator, and I hope a normal human being.
Do you really believe there should be no consequence for Hillary Clinton and how she dealt with this?
Well, I didn't say, I hope folks remember what I said on Tuesday. I didn't say there's no consequence for someone who violates the rules regarding the handling of classified information. There are often very severe consequences in the FBI involving their employment, involving their pay, involving their clearances. That's what I said on Tuesday, and I hope folks walk away understanding that just because someone's not prosecuted for mishandling classified information, that doesn't mean if you work in the FBI, there aren't consequences for it.
So, if Hillary Clinton, or if anybody had worked at the FBI under this fact pattern, what would you do to that person?
There would be a security review and an adjudication of their suitability, and a range of discipline could be imposed from termination to reprimand, and in between suspensions, loss of clearance. So you could be walked out, or you could, depending on the nature of the facts, you could be reprimanded. But there is a robust process to handle that.
I've gone past my time. I yield back. Now recognize the ranking member, Mr. Cummings.
Thank you very much, Director Comey, and I want to thank you very much for being here today, especially on such short notice. You and your staff should be commended for the thorough and dedicated review you conducted. Unfortunately, some of my colleagues are now attacking you personally because your final recommendation conflicted with their preconceived political outcome in this case. Some have tried to argue that this case is far worse than the case of General David Petraeus, who was convicted in 2015 of knowingly and intentionally compromising highly classified information. In fact, one very vocal politician we all know said this, and I quote, "If she isn't indicted, the only reason is because the Democrats are protecting her." She is being protected 100%. Because you look at General Petraeus, you look at all the other people that did a fraction of what she did. But she has much worse judgment than he had, and she's getting away with it, and it's unfair to him, end of quote. Director Comey, you were the director of the FBI when General Petraeus pled guilty, is that right?
Yes.
If I understand that case correctly, General Petraeus kept highly classified information in 8 personal notebooks at his private residence. Is that correct?
That is correct.
According to the filings in that case, his notebook included the identities of covert officers. They also included war strategy, intelligence capabilities, diplomatic discussions, quotes and deliberative discussions from high-level National Security Council meetings and discussions with the president. General Petraeus shared his information with his lover and then biographer. He was caught on audio tape telling her, and I quote, "I mean, they are highly classified, some of them. They don't have it on it, but I mean, there's code word stuff in there," end of quote. Director Comey, what did General Petraeus mean when he said he intentionally shared, quote, code word information with her? What does that mean?
The Petraeus case, to my mind, illustrates perfectly the kind of cases the Department of Justice is willing to prosecute. Even there, they prosecuted him for a misdemeanor. In that case, you had vast quantities of highly classified information, including special sensitive compartmented information. That's the reference to code words. Vast quantity of it, not only shared with someone without authority to have it, but we found it in a search warrant hidden under the insulation in his attic, and then he lied to us about it during the investigation. So you have obstruction of justice, you have intentional misconduct, and a vast quantity of information. He admitted he knew that was the wrong thing to do. That is a perfect illustration of the kind of cases that get prosecuted. In my mind, it illustrates, importantly, the distinction to this case.
And General Petraeus did not admit to these facts when the FBI investigators first interviewed him, did he?
No, he lied about it.
But he did admit to these facts in a plea agreement, is that correct?
Yes.
Here's what the department filing said about General Petraeus, and I quote, "The acts taken by defendant David Howell Petraeus were in all respects knowing and deliberate, and were not committed by mistake, accident, or other innocent reason," end of quote. Is that an accurate summary in your view, Director Comey?
Yes, it actually leaves out an important part of the case, which is the obstruction of justice.
Was he charged with obstruction of justice?
No.
And why not?
A decision made by the leadership of the Department of Justice not to insist upon a plea to that felony.
So the question is, do you agree with the claim that General Petraeus, and I quote, got in trouble for far less, end of quote? Do you agree with that statement?
No, it's the reverse.
And what do you mean by that?
His conduct, to me, illustrates the categories of behavior that mark the prosecutions that are actually brought. In clearly intentional conduct, knew what he was doing was a violation of the law. Huge amounts of information that even if you couldn't prove he knew it, it raises the inference that he did it. Right? An effort to obstruct justice. That combination of things makes it worthy of a prosecution. A misdemeanor prosecution, but a prosecution nonetheless.
Sitting here today, do you stand by the FBI's recommendation to prosecute General Petraeus?
Oh, yeah.
Do you stand by the FBI's recommendation not to prosecute Hillary Clinton?
Oh, yes.
Director Comey, how many times have you testified before Congress about the General Petraeus case? Do you know?
I don't think I've ever testified. I don't think I've testified about it at all. I don't think so.
With that, I'll yield back.
I have to check the record, but I believe I asked you a question about it at the time, but maybe not.
You could have. That's why I was
yeah.
squinching my face. It could have been a Judiciary Committee hearing I was asked about it.
Yeah. We'll now recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Good morning, Director Comey. Secretary Clinton said she never sent or received any classified information over her private email. Was that true?
Our investigation found that there was classified information sent.
So it was not true.
Right. That's what I said.
Okay. Well, I'm looking for a little shorter answer so you and I are not here quite as long. Secretary Clinton said there was nothing marked classified on her emails either sent or received. Was that true?
That's not true. There were a small number of portion markings on, I think, 3 of the documents.
Secretary Clinton said, I did not email any classified material to anyone on my email. There is no classified material. Was that true?
There was classified material emailed.
Secretary Clinton said she used just one device. Was that true?
She used multiple devices during the 4 years of her term as Secretary of State.
Secretary Clinton said all work-related emails were returned to the State Department. Was that true?
No, we found work-related emails, thousands, that were not returned.
Secretary Clinton said neither she nor anyone else deleted work-related emails from her personal account. Was that true?
That's a harder one to answer. We found traces of work-related emails. on devices or in Slack space, whether they were deleted or whether when a server was changed out, something happened to them. There's no doubt that there were work-related emails that were removed electronically from the email system.
Secretary Clinton said her lawyers read every one of the emails and were overly inclusive. Did her lawyers read the email content individually?
No.
Well, in the interest of time, and because I have a plane to catch tomorrow afternoon, I'm not going to go through any more of the false statements, but I am going to ask you to put on your old hat. False exculpatory statements, they are used for what?
Well, either for a substantive prosecution or for evidence of intent in a criminal prosecution.
Exactly. Intent and consciousness of guilt, right? Is that right?
Right.
Consciousness of guilt and intent. In your old job, you would prove intent, as you just referenced, by showing the jury evidence of a complex scheme that was designed for the very purpose of concealing the public record. And you would be arguing, in addition to concealment, the destruction that you and I just talked about, or certainly the failure to preserve. You would argue all of that under the heading of intent. You would also be arguing the pervasiveness of the scheme, when it started, when it ended, and the number of emails, whether they were originally classified or upclassified. You would argue all of that under the heading of intent. You would also probably, under common scheme or plan, argue the burn bags of daily calendar entries or the missing daily calendar entries as a common scheme or plan to conceal. 2 days ago, Director, you said a reasonable person in her position should have known a private email was no place to send and receive classified information. You're right, an average person does know not to do that. This is no average person. This is a former First Lady, a former United States Senator, and a former Secretary of State that the President now contends is the most competent, qualified person to be president since Jefferson. He didn't say that in 08, but he says it now. She affirmatively rejected efforts to give her a state.gov account. She kept these private emails for almost 2 years and only turned them over to Congress because we found out she had a private email account. So you have a rogue email system set up before she took the oath of office. Thousands of what we now know to be classified emails, some of which were classified at the time. One of her more frequent email comrades was in fact hacked, and you don't know whether or not she was. And this scheme took place over a long period of time and resulted in the destruction of public records, and yet you say there is insufficient evidence of intent. You say she was extremely careless, but not intentionally so. You and I both know intent is really difficult to prove. Very rarely do defendants announce, on this date, I intend to break this criminal code section.